Mesdames et messieurs,
ladies and gentlemen, allow me to welcome you here in Strasbourg at the European Court of Human Rights. It's a privilege and an honor for me to be introducing this conference, which is organized under the auspices of the European Society for International Law and of the European Court of Human Rights. This conference will be given by my colleague and friend, Linos-Alexandre SICILIANOS, who is a prominent personality in international law and a member of the Institute for International Law and a judge at the European Court of Human Rights. As president of the court, I'm often asked what the major challenges are that the European Court of Human Rights has to face. Well, I think that one of the major challenges, perhaps the most significant of all, is the position of the European Court of Human Rights in the context of the crisis we're experiencing in Europe, and which is illustrated through a number of issues and problems. The crisis affects conventional rights, where we traditionally afford considerable margin of appreciation to the states, but the crisis also affects other areas. I'm thinking of the crisis of the refugees and migrants and the delicate issues of international law and the link between the European Convention of Human Rights and international humanitarian law, in particular when it comes to armed conflict. And then, of course, the crisis is also linked to the fight against terrorism. And this is an area where our court has always stood firm. Very often when we talk about the fight against terrorism, well, as judges, we need to bear in mind that this does also involve non-derogable rights. And I would like to give the floor to Judge Sicilianos at this point, without further ado, to discuss this particularly difficult question. Over to you. Thank you very much, President. Thank you very much, Dean. Allow me, first of all, to thank you very warmly for having accepted to introduce and to chair today's session. Let me also very warmly thank the agents of the court who encouraged me and helped me in the co-organisation of this conference. Thank you also very much for the Society for International Law. Dear ambassadors, colleagues, ladies and gentlemen, it would be a truism to say that Europe is currently experiencing a serious crisis. Until recently, one thought that this crisis was economic, mainly. The flows of refugees are unprecedented since the Second World War, and they've added a new dimension to the situation. Furthermore, as was amply demonstrated in the Paris attacks in January, but also the attacks in Isère in Tunisia and in Kuwait in June of this year, or in Turkey on last Saturday, the rise in extremism and terrorism, or even in barbarity, is taking on proportions which are increasingly worrying. In parallel to this, we're seeing new armed conflict breaking out. We have persisting conflicts on our continent or near our region. And there are other features to this rather somber depiction of the Europe of today. But I think that these four aspects, the economic crisis, the crisis for the refugees, the increase in terrorism and armed conflict, I think these are the most salient features in the present circumstances. All these problems give rise to extraordinary human suffering and serious breaches of human rights. In these conditions, one may legitimately wonder whether the institutional and legal framework which was built to protect our common heritage of ideals and political traditions, as our preamble says, is strong enough to face up to these challenges. If we agree that the European Convention of Human Rights is one of the most valuable treasures created by European civilization, and the European Court of Human Rights is the body par excellence which is in charge of ensuring compliance with the commitments resulting from this instrument, one might want to look at the role that our own court plays in this crisis. Since the Interlaken Conference and up to the Brussels Conference, there has been much discussion on the difficulties of the court when it comes to its functioning, the question of the backlog of cases, the court's productivity, and etc. One often tends to forget that the Court of Strasbourg is faced with the most difficult issues on our continent. It has had to take a stand on the human consequences of the economic crisis. It is gradually becoming a major actor in the context of the refugee crisis. It has received applications involving the most sensitive and even the most dramatic terrorist cases. It has been asked to rule on all the armed conflicts which have broken out on our continent over the last decades, including the conflict in Ukraine, which gave rise to 4 interstate applications and over 1,400 individual applications. So rather than dealing once again, I would say, with the procedural aspects of the court's functioning, I would like to focus today on the actual challenges that the court has to face, including and beginning with the economic crisis. The first point I would like to make here is to refer to the considerable impact of this crisis on the rights protected by the Convention. The traditional approach, according to which civil and political rights have no significant cost and that consequently they are not overly affected in the cases of economic difficulties, is turning out to be completely wrong. Effective protection of human rights has a cost. It's quite a heavy one. The Convention certainly lends itself to financial interpretation as well, which means that pressures on state budgets have a tangible and direct impact on a series of rights protected by the Convention. We know that according to the case law of the court, many, or rather several of these rights involve positive obligations incumbent upon states. Now, all positive obligations for states necessarily lead to public expenditure because they presuppose the setting up of appropriate public services. This is the case, for example, when it comes to the state's obligation to ensure conditions of detention which are in compliance with the requirements of Article 3 of the Convention. Suffice it to look at the latest criminal statistics of the Council of Europe to see that the economic crisis has an adverse effect on these conditions in European prisons, including in strong states such as France or Italy. The multiplication of applications linked to conditions of detention in Croatia, in Greece, Hungary, Poland, Romania, Russia or Ukraine bear witness to the magnitude of this phenomenon. And there is a similar situation, mutatis mutandis, in connection with the right to a fair trial. Clearly, a fair trial, with all of the safeguards stemming from Article 6 of the Convention, also involves considerable cost. The situation is also worsening, in fact spectacularly so, when it comes to the treatment of aliens and asylum seekers. In the case of Hirsi Yama and others against Italy, the Grand Chamber explicitly underlined the magnitude of the problem by observing in 2012, and I quote, that the context of the economic crisis faces European states with new challenges in the area of immigration management. I would say more than this, in fact. The economic crisis combined with the migration crisis leads to a steep rise in xenophobic and extremist tendencies. These tendencies which in turn threaten the pillars on which the Convention is based, that is democracy and human rights and the rule of law. Now, in addition to this very worrying situation, the economic crisis is leading states to taking major economic policy decisions which often have a painful impact on property rights for our citizens. What is the court's position on this? First of all, the court has examined several applications linked to legislative measures which affect salaries and pensions cases against Romania, Bulgaria, Greece, Portugal, Hungary or Lithuania. The case of Koufaki and Adedi against Greece in 2013 was perhaps the most significant of those. It dealt with the cut in salaries, pensions and other social benefits as a consequence of the austerity measures adopted in 2010 and 2011. This case is both banal and extremely important. It's banal insofar as it follows the constant case law of the court, that is, that the property right does not guarantee a specific salary or pension. And it's important because the court places itself explicitly in the context of an exceptional and unprecedented crisis in the recent history of Greece. A crisis which has shaken the credibility of the country while seriously threatening the national economy. This is a very serious tone which refers to the difficult situation we are aware of, and the court affirmed that in these circumstances a decision to adopt laws affecting the balance between the budget's the expenditure and its receipts involved the examination of political, economic and social questions. Legislators have considerable leeway here, and unless they are arbitrary or unreasonable, the decisions taken, the legislative decisions taken in a context of a crisis come under the margin of appreciation. The international judge applies the subsidiarity principle. It's not up to the international judge to deal with economic policy. This decision has been upheld on several occasions in connection with the austerity measures in Portugal, or the case of Savickas against Lithuania dealing with reduction in salaries for judges. It was only in one case against Hungary that the court found a breach of property rights connected to austerity measures. This case involved a social benefit, part of which was subjected to a 98% tax. It appears that it's only sparingly and in exceptional cases, such as in this Hungarian case, that the court intervenes in the priority decisions and economic measures. However, the court is much more strict when it comes to preserving non-derogable rights. With regard to the rights which are part of the hardcore of the Convention, the court has focused in its attention on the consequences of the economic crisis, in particular when it comes to conditions of detention. In the case of Ochowski against Poland, for instance, the court has affirmed that lack of resources could not justify conditions of detention which are incompatible with Article 3 of the Convention, that is, the ban on torture and inhuman or degrading treatment. States must organise their prison systems so as to respect the dignity of inmates, regardless of financial and logistical difficulties. This is what the court says. And the court adds that if the state is not in a position to provide conditions of detention in compliance with Article 3, it must relax its criminal policy in order to reduce the number of prisoners. Therefore, the court creates a sort of performance requirement for states with a view to ensuring respect of conditions of detention in compliance with Article 3, including, if this involves, amending their criminal policy. There is similar reasoning which can be applied to the right of a fair trial, which is a keystone, of course, in the system of the Convention. The state cannot invoke a lack of resources to justify excessive length of domestic proceedings. Neither can the state invoke such financial difficulties in order to justify failing to pay a debt subsequent to a judicial decision. The court does not accept discriminations against underprivileged groups, which allegedly are linked to financial difficulties either. It has underlined, for instance, that unlike other social benefits, the right to education is directly protected by the Convention, a right which is essential for individual fulfilment. In these conditions, the obligation for aliens who do not have a residence permit to pay school fees for secondary school education amounts to discriminatory treatment. The non-discrimination principle is all the more important that this is a transversal principle in the international human rights protection system. It therefore emerges that in the face of the economic crisis, the court is adopting a position which is both cautious and firm. It highlights the consequences of the crisis on a series of rights protected by the Convention. At the same time, it invokes the subsidiarity principle in order to avoid intervening in major decisions which reflect political choices in economic matters, choices which are up to the sovereign power of the state. Nevertheless, the Court protects the hard core of the Convention and refuses to enter into economic considerations when it's a matter of protecting non-derogable rights. Let me now move on to the second chapter of my intervention.
Et des réfugiés. Il importe de rappeler à cet endroit que, contrairement à la Charte des droits fondamentaux, le système de la Convention ne prévoit pas le droit d'asile.
The Convention system does not cover the right of asylum. Apart from a few provisions on expulsion proceedings, the Convention does not recognise rights for aliens as such. Now, however, to quote the Grand Chamber in the case of Georgia against Russia, number 1, although states can sovereignly establish their immigration policies, difficulties with the management of migratory flows cannot justify practices which are incompatible with their convention obligations. This sentence summarises the Court's approach. On the basis of general convention provisions, the Court has created a whole set of standards which amount to a compass for the states parties, but also for the European Union. This case law reinforces the Geneva Convention of 1951 on the status of refugees and highlights the remits of the Dublin Regulation whilst establishing the foundations of migratory policies for states. When it comes to the Geneva Convention, as we know, the non-refoulement principle is the cornerstone of it. But this principle is not absolute. A refugee can indeed be deported exceptionally when they represent a threat for the safety of the state or when they've committed a serious criminal offence. However, the Court bans absolutely the deportation of a person who might be exposed in the state of destination to a real risk of treatment contrary to the right of life or the ban on torture. As the Court has found, the prospect that the person concerned might be a serious threat for the community does not in any way diminish the risk that they might be subjected to ill treatment were they to be deported. This is the case of Sadi against Italy. This absolute ban on deportation applies not only to refugees and asylum seekers, but also to persons who are not even able to make such an application. The judgment of Sharifi and others against Italy and Greece in 2014 on automatic refoulement operated in the Adriatic Sea harbours illustrates this issue very strikingly. In exceptional circumstances, the existence of general violence or an armed conflict have been considered as sufficient as such to rule out deportation. The case of Soufi and Elmi against the United Kingdom on the blind violence which is rife in Somalia is a very good example of this case law. This case law, in fact, could be transposed, mutatis mutandis, to certain current conflicts, such as the conflict in Syria. It therefore appears that the ban on deportation under the Convention is both stronger and broader than the principle of non-refoulement of the Geneva Convention. One could also recall that since the judgment of the Grand Chamber in MSS against Belgium and Greece, the Court on several occasions has found a breach of the Convention because applicants had no access to asylum procedures, combined with the risk of deportation to a country where they were likely to be ill-treated. In other terms, although the right of asylum is not recognised as such by the Convention, serious deficiencies linked to asylum proceedings are found to amount to an autonomous violation of the Convention. This finding leads me to refer to the case law of the Court on the Dublin Regulation. Although the text of the Dublin Regulation has been amended and updated over time, its philosophy is still the same as under the Dublin Convention of 1990, although it is sometimes presented as a mainly procedural instrument because it merely determines which state is responsible for processing an asylum application. This regulation actually reflects a very important political choice and creates a considerable burden on those states who first come into contact with asylum seekers. However, the Dublin Regulation also contains a way out, the sovereignty clause, as it is called, which enables states to derogate from the criteria and to examine an asylum request themselves. It was on the basis of this clause that in MSS against Belgium and Greece, the court concluded that when they apply the Dublin Regulation, states must ensure that the asylum procedure in the intermediary country, Greece in the instant case, offers sufficient guarantees in order to avoid an asylum seeker from being deported to their country of origin without assessing the risks they might face. And the court has found that the systemic deficiencies in the asylum proceedings in Greece, and this term was taken up by the Court of Luxembourg in the case of NS, is currently used also in Dublin 3. That is, that the wording of our court has direct influence on the actual wording of this third version of the Dublin Regulation. In the case of Tarakel against Switzerland, the Grand Chamber of the Court stressed that the requirement of protection, special protection for asylum seekers, is all the more important when we're dealing with children. The court has taken into consideration the particular needs and the extreme vulnerability of the applicant's family. Although reception conditions in Italy do not reveal the existence of systemic deficiencies, unlike in MSS, they were nevertheless problematic. In these conditions, the court demanded that the Swiss authorities obtain from Italian authorities individual safeguards before the family could be sent back to Italy. Guarantees on the care provision which would be given to the children and which had to be adapted to their age, and guarantees when it came to protecting the family unit. In other terms, the court discarded the automatic nature of the system as it exists under Dublin to focus on the interest of the children in the context of Article 3 of the Convention. Finally, in the case of Sharifi and others against Italy and Greece, the court has recalled that the application of the Dublin system has to be consistent with the European Convention, and no form of collective deportation can therefore be justified with a reference to that system. It also appears that the court has highlighted the need for rethinking the Dublin system well before the refugee crisis reached its current proportions. Since then, several persons have spoken out, including the Human Rights Commissioner of the Council of Europe, appealing to fundamentally review the Dublin Regulation. And this is something the Commissioner said recently in an interview to Le Monde. Furthermore, the case law of the court has gradually laid down foundations for the migration policy of states and has also influenced the policy of the European Union. This is the case in particular for detention conditions for migrants or asylum seekers in detention centres. The recent case of Khalifa and others against Italy in September, which concerned inter alia the conditions of detention on the island of Lampedusa, is particularly interesting from this point of view. Indeed, before a situation which appears as a humanitarian crisis, the Italian government explicitly invoked the state of necessity as a circumstance to exonerate it from its responsibility. The court recognised the constraints weighing on the Italian authorities, but nevertheless rejected this argument. These constraints cannot exonerate the respondent state from its obligation to guarantee conditions of detention which are compatible with respect for human dignity. The court, in this connection, recalled the absolute and imperative nature of Article 3 of the Convention. In a similar context, the case of MSS against Belgium and Greece highlighted the question of the conditions of existence of asylum seekers whilst they're waiting for their application to be processed. And one should recall in this connection that the applicant was free, was not in detention at that point. The court nevertheless considered that the Greek authorities had failed to take into account the applicant's vulnerability as an asylum seeker. And because of their passive attitude, they had to be held responsible for the conditions of extreme poverty that this applicant was in for several months. Several judgments also deal with the question of the lawfulness of detention of migrants. Such detention is lawful if deportation proceedings are pending. If deportation turns out to be impossible, detention is no longer justified. When it comes to the detention of asylum seekers in particular, the court assesses whether it would have been possible to apply a less radical measure, a measure which could replace deprivation of liberty. And along these lines, in Khalifa against Italy, the court recently found that de facto detention of the applicants in the Lampedusa detention centre lacked a legal basis in Italian law and therefore that it was incompatible with the requirements of Article 5 of the Convention. Another particularly important point in the context of the current crisis is that of collective deportation. Since the judgment of Chonka against Belgium and until the Khalifa judgment, and including Hirsi Jama Sharifi and others, the court has underlined that deportation proceedings must take into consideration the individual situation of the persons concerned. To determine the existence of collective deportation, the court looks at several elements. The existence of similar refoulement decisions, the absence of individual interviews, the fact that it was not possible to contact a lawyer, or the fact of many people of the same origin are subjected to the same fate, etc. And even the identification procedure is not sufficient to rule out the existence of collective deportation. Now, when it comes to condition of detention of migrants, conditions of existence of asylum seekers, lawfulness of detention, collective deportation, these are the four main questions linked to the current migration crisis and refugee crisis that the court has taken a clear stand on. And this case law is bound to be added to in the future. But we can already say that the court's positions and decisions set significant limits for states when it comes to the migrant and refugee crisis. There is another important area that the court has had to deal with. That is the fight against terrorism that the President has already referred to. This is a recurring problem, in fact, that the court was faced with from the beginning. The first case, the lawless case, was a terrorism case. However, the surge and the magnitude of the terrorist attacks and the broad range of anti-terrorist measures taken over the last years have triggered applications which have considerably added to these terrorism-related cases. If we look at the main feature of this abundant case law, we can see, first of all, that the court has sometimes shown to be understanding in the face of the difficulties that domestic authorities are faced with. We can in particular mention the case of Othman Abu Qatada against the UK, which caused a stir in the United Kingdom. The applicant, who'd been sentenced in Jordan for terrorist acts, claimed that he would be exposed to a real risk of torture were he to be sent back to Jordan. The United Kingdom invoked, amongst other things, the diplomatic assurances obtained from Jordan. The court, after having summarised its case law on diplomatic assurances and carefully analysed the assurances provided in this case by the King himself, admitted the British argument in this case. Now, it is particularly rare for the court to rely mainly on diplomatic assurances. In principle, it tends to be less trusting. When it comes to the ban on torture in the case of Ramirez Sanchez against France, better known under the name of Carlos, the Grand Chamber of the court took into consideration the personality and the particular dangerousness of the applicant to consider that detention in solitary confinement for 8 years was not in breach of Article 3 of the Convention. We had another example with Finogenov and others against Russia. Now, as we know, this case concerned the assault of a theatre in Moscow by Chechen separatists and the decision to incapacitate the terrorists and to free the hostages by spraying gas. The court concluded that the non-breach of the right to life, when it comes to the decision to solve this hostage crisis by resorting to gas and resorting to force. Now, this case is interesting from the point of view of general international law as well. The state of necessity is not expressly mentioned, but the wording used by the court does very much bring to mind this notion of state of necessity. There would be many examples we could quote. Without touching on the major principles of its case law, the court often takes into account the considerable difficulties created by the fight against terrorism to recognise greater leeway to the domestic authorities and, when it comes to their margin of appreciation, to underline the existence of imperative reasons justifying the state of necessity, etc. At the same time, the court takes pains to reaffirm the relevance of the principles of its case law, even in this very delicate context of anti-terrorist measures.
So, we should stress that our court cut short the doctrinal debate which took place in the United States following the 9/11 terrorist attacks concerning the scope of the ban on torture. Both the Grand Chamber, in the case of Sadi against Italy, and the chambers in the court have forcefully asserted the absolute nature of the prohibition of torture and inhuman or degrading treatment, irrespective of the conduct of the person concerned, and even in the most trying circumstances, such as the fight against terrorism. More recently, in Trabelsi against Belgium, the court reasserted, in a terrorist-related case, that a full life sentence with no possibility of conditional release is contrary to Article 3 of the European Convention on Human Rights, and this is a reassertion of the Winterwerp against United Kingdom case law. The court also condemns detention for an unspecified period for foreigners who are suspected of involvement in terrorist activities. As for the secret charter flights of the CIA, the court has pilloried these, calling them totally incompatible with the rule of law in El Masri and in other more recent cases. The court has also demonstrated its commitment to the principles of its case law, dealing with matters of more traditional freedoms protected by Articles 8 to 11 of the Convention. By way of example, I might mention Güler and Uyghur against Turkey, stressing that the anti-terrorist laws should not be used as a pretext to restrict legitimate religious activities. So these few examples demonstrate that because of this broad spectrum of rights addressed, the court adheres to the traditional principles of its case law despite the terrorist context. In other words, the court does not want to be trapped in a specious dilemma to choose between security or liberty. Its message is that these two important values in our societies need to coexist, both liberty and security. Furthermore, terrorist-related cases have made it possible to make many major advances in the case law. In this field as well, there are a great many examples. Now, I'm not aiming to be exhaustive here, but I'd like to mention, first of all, an institutional improvement concerning the mandatory nature of interim measures. We know that the possibility of adopting these measures is not mentioned as such in the Convention. It appears in Rule 39 of the Rules of Court. Up to 2005, the court had never asserted the mandatory nature of these measures. It was in relation to a terrorist case, Mamat Kulov and Askarov against Turkey, concerning the extradition of the applicants to Uzbekistan, that the court took a major step forward. Drawing on the position of the ICJ in the Lagrange case, as well as the case law of the Inter-American Court of Human Rights, the Strasbourg Court held that the interim measures did have a mandatory effect which seeks to secure the effectiveness of individual petitions. So this development has had a major impact on the case law of the court. Among the many advances in the interpretation of the substantive provisions of the Convention, I'd like to mention again the Grand Chamber judgment in El Masri, which enshrined for the first time ever the right to know the truth concerning the procedural obligation to investigate ill treatment suffered by the applicant. In the Othman or Abu Qatada case I already mentioned, the court found for the first time in its history that the expulsion to a foreign country, Jordan in that case, would violate Article 6 of the Convention, given that there was a real risk for the applicant to suffer a flagrant denial of justice. That's to say, the extraterritorial scope of Article 3, but also of Article 6. Still within the sphere of Article 6, and more particularly the rights of the defence, the court has asserted in Saldus against Turkey the right of the accused to enjoy assistance from a lawyer during the early stages of police questioning. Furthermore, in the case of Nada against Switzerland, the court took further its analysis of the relations between Security Council sanctions, inclusion of the applicant on the blacklist, and the convention system. It didn't argue in terms of a hierarchy or clash between the two systems. The court, quite the contrary, stressed the need for a harmonious interpretation of the obligations which stem from them. I could give a great many other examples, but viewed as a whole, the case law linked to terrorist cases is both cautious and balanced. The court has shown understanding in the face of the sometimes extreme difficulties involved in fighting terrorism without betraying the principles of its case law, which quite the contrary have been reaffirmed and strengthened. It has even detailed and refined its approach in the context of the ever-evolving interpretation of the Convention. I'll now move on to the fourth and final part of my presentation, the attitude of the court to armed conflicts. Perhaps I could start with one preliminary point. All the conflicts that have taken place on our continent, at least since 1990, have been or are being tackled in one way or another by our court. I might mention a range of cases concerning conflicts following the breakup of the Soviet Union. In the Iliescu and others against Moldova and Russia judgment, the Grand Chamber asserted the extraterritorial scope of the Convention and had to establish in extensive terms the background of the case, namely the factual evidence leading to the conclusion that Russia did exercise its jurisdiction over Transnistria, a finding that was upheld in the judgments Ivantoch and Katan. Two other cases, judged by the Grand Chamber of the Court, concern the conflict between Armenia and Azerbaijan over Nagorno-Karabakh. These were the Chiragov against Armenia and Sargsyan against Azerbaijan judgments. Even if these were lodged by way of individual petitions, these applications did have an interstate dimension, given that the Armenian government intervened in the case against Azerbaijan and vice versa. As part of applications linked to the breakup of the Soviet Union, I might pick out the second Georgia against Russia application, which is currently pending, dealing with events from 2008, as well as the interstate applications, Ukraine versus Russia, concerning the Crimea question and the situation in the east of Ukraine, not to mention a great many individual applications which are also pending against the same background. The conflict in the former Yugoslavia and its effects, the intervention by NATO and the events in Kosovo, have also been the subject of several applications. Admittedly, in two of the most famous cases, Bankovic and Berami and Saramati, the court held that it had no jurisdiction. However, other, more specific aspects of the Yugoslav conflict have been examined on the merits. This was the case in Margus against Croatia, where the Grand Chamber had the opportunity to affirm that amnesties for war crimes and crimes against humanity are incompatible with international law. In the case Djordjic against Germany, the court explored the concept of genocide, more particularly the question whether ethnic cleansing was part of the concept. Finally, among cases dealing with the disastrous economic consequences of the Yugoslav conflict, I might mention the Grand Chamber judgment in Alizic and others, which is now a leading precedent with respect to debts incurred in matters of state succession. I might also recall that the court has handed down no less than 280 judgments concerning the conflict between the Turkish security forces and the PKK, and roughly 230 judgments on the conflict in Chechnya, most of which dealt with forced disappearances. The main aspects of the Cypriot question were tackled inter alia in the 2001 judgment on the fourth interstate application Cyprus against Turkey, supplemented in 2014 with judgment given by the court on just satisfaction. That judgment was unprecedented in the history of the court, inter alia because it applied Article 41 of the Convention to an interstate application, but also because it invited the applicant government, Cyprus, to distribute the amounts awarded to individual victims. From the standpoint of general international law, this judgment reflects the law on state liability as well as recent developments in the law on diplomatic protection with the distribution of the award to individual victims. Finally, last but not least, the conflict in Iraq has been the subject of important judgments of the Grand Chamber against the United Kingdom, Al-Skaini, Al-Jeddah Hassan, or the Netherlands, Jalud. These have all been opportunities for the court to examine issues relating to state jurisdiction, the extraterritorial application of the Convention, problems of attribution, the responsibility of the state acting with the authorization of the Security Council, or the applicability of international humanitarian law. So this rapid overview demonstrates to what extent the Strasbourg Court has had to involve itself in the most distressing chapters of the recent history of our continent, in the most sensitive cases involving contemporary political events. It's had to confront thorny issues of general international law, not to mention difficulties involved in establishing the facts. Furthermore, the pending cases on the Ukrainian and Georgian conflicts, but also the 2014 judgment on the Cypriot question, have prompted us to take a closer look at the renewal of interstate applications. In this connection, it should be recalled that among all the human rights conventions providing for interstate applications, only the European Convention has actually been relied on to lodge such applications, and the other relevant instruments, be they universal or regional, these applications remain a purely theoretical possibility. However, in the convention system, interstate applications have, from the very inception, been an essential component of the collective guarantee for the protected rights. It was enshrined in the original text of the instrument, has never been subject to prior endorsement by the contracting states. The existence of this remedy is evidence of the erga omnes partes nature of all obligations flowing from the Convention. In point of fact, given that the violation of these obligations, be they substantive and procedural, may be the subject of an application by any contracting party, it's obvious that the obligations at issue are assumed with respect to all, and this is a point which was stressed by the court in the Ireland versus United Kingdom in 1978. Furthermore, any state which lodges an interstate application should not be considered as defending its own rights, but rather as raising an issue which relates to public policy in Europe, to use the words of the former Commission in the Austria against Italy case, as was appositely pointed out by our President in a recent article. The interstate application means that the court is given prominence as the guarantor of a pacified public order in Europe. The establishment of the interstate application, which was already included in the original convention text of 1950, was the forerunner of the concept of erga omnes obligations, long before the concept was officially recognised by the ICJ in 1970. It was at the origin of the conceptual process which gradually led to the emergence of the concept of jus cogens, so imperative rules in international law, and consequently the hierarchical system of the international legal order. So the interstate application under our convention has had an influence on the actual structure of international law. Concerning more particularly the importance of interstate applications that have occurred more recently, it should be said that the fourth Cyprus against Turkey application led the court to pass judgment on the main aspects of the Cypriot question: refugees, displaced persons, forced disappearances, property rights, as well as the issue of compensation for the victims. The pending applications, Georgia and Ukraine against Russia, will lead the court to decide issues relating to the applicability of international humanitarian law, state responsibility, especially issues of attribution and control, to the annexation of territories and its effects on individuals. Now, in the context of recent interstate applications, the court has had to adopt interim measures under Rule 39 of its Rules of Court. This is a major step forward if you bear in mind that up until now, interim measures were only adopted with respect to individual applications. Now, given the breadth of the issues at stake, some might wonder whether consideration of these interstate applications is really in keeping with the nature, the role or mission of the court as a court specialised in human rights matters. Well, I consider that clearly it does. Once an application is deemed admissible, it's hard to imagine that the court could evade its duty to ensure respect of the commitments for the contracting parties under the Convention and its protocols. That's what's stated in Article 9 of the Convention, admittedly. An interstate application will inevitably contain a political dimension. However, that did not discourage the draftsman of the Convention for making this application a key component in the collective guarantee system under the Convention. In addition, as was quite rightly pointed out by the ICJ, most of the issues arising in international life, because of their very nature, do have a political dimension. Now, the fact that an issue that is raised may contain some political features should not rob it of its legal nature or rob the court of this competence expressly conferred upon it by its statute. I'm quoting here from the advisory opinion on the lawfulness of the threat or use of nuclear weapons. So this vision of things applies mutatis mutandis to our court, the European Court of Human Rights, to argue, furthermore, that a judgment concerning aspects of an armed conflict and human rights may not really be very effective and will raise difficulties of execution is not a convincing argument either, for various reasons. First of all, a similar argument might be made out against any judgment coming from an international court. To take a stand, for example, on the lawfulness of using nuclear weapons or the lawfulness of the use of force isn't going to change much on the ground. But this doesn't mean in any way that such a judgment would have no importance or that it might not play a significant role in diplomatic terms. The same applies to a judgment which might establish the extent of violations of human rights or the extent of state liability in this context, in the context of armed conflicts. During such conflicts, there will inevitably occur atrocities, violations, often serious of human rights and international humanitarian law. To disregard the human aspect of an armed conflict would be totally inappropriate given the present developments in international law. But of course we do need to explore whether and to what extent the court can apply not only the Convention but also international humanitarian law in such circumstances. Now, for decades, and until quite recently, the court was very reticent about applying international humanitarian law, IHL, and this should come as no surprise. As was stressed by the dissenting colleagues in Hassan, Article 19 of the Convention stipulates in substance that the court has competence to apply the Convention, the whole Convention, and nothing but the Convention. The main exception to this conception is provided by the derogation clause of Article 15 of the Convention, which refers to other obligations of the state concerned stemming from international law. In point of fact, the Court considers in principle that the possible application of humanitarian law would require the operation of the derogation clause, as evidenced by the Chechen cases. Unless a respondent state invokes Article 15 of the Convention, the Court, in principle, will apply the Convention principles without allowing any derogation which might flow from parallel application of humanitarian law. Furthermore, it's significant that even where a respondent state invokes Article 15 of the Convention in the context of a state of emergency concerning part of its territory, the Court will carefully avoid referring to the law of non-international armed conflicts. This was the case in the so-called Kurdish cases. So alongside this reserved attitude, we see an opening up, a timid opening up, but significant in relation to IHL in international armed conflicts. For example, in the context of the Cypriot conflict, the court held in Vanova, among others, and I quote, that Article 2, the right to life, should be interpreted as far as possible in the light of the principles of international law, inter alia, the rules of international humanitarian law. In that case, humanitarian law was relied on to corroborate the interpretation of the Convention. The obligations under humanitarian law mesh with those of the European Convention. In other cases, the Court examined as an ancillary feature international humanitarian law, in Kononov, for example, or took it into account, considering, however, that it did not provide any conclusive response to the crucial issue in that case, to quote from Sargizan against Azerbaijan. However, the turning point of the attitude of the court concerning international humanitarian law was heralded by the Hassan versus United Kingdom case. This case concerned the arrest and detention of the applicant's brother by the British forces in Iraq in April 2003. The acts at issue were ordered pursuant to the powers conferred on the United Kingdom by the Third and Fourth Geneva Conventions. However, this detention corresponds to none of the categories listed in subparagraphs A to F of Article 5, paragraph 1 of the Convention. Now, these stipulations are listed exhaustively. In other words, any detention which does not come under any of these categories is, in principle, contrary to Article 5 of the Convention. So, in a word, the contentious arrest and detention were permissible on the basis of humanitarian law, whereas they wouldn't have been under the Convention. In its judgment, in Hassan, the Grand Chamber quoted the position of the ICJ on the interplay between international humanitarian law and human rights. We know, in fact, that the Hague Court has distinguished between three situations. In this respect, some rights may relate exclusively to international humanitarian law, others may pertain exclusively to human rights, and others may indeed come under both of these branches of international law. I'm quoting from the Advisory Committee on the Building of a Wall in Palestinian Territory. So the Hassan judgment is fully in keeping with this spirit, dealing with a situation which fell under both IHL and human rights. The European Court adopted an approach which sought to harmonise the obligations flowing from these two branches rather than opposing them, while being aware that the contentious internment was not in keeping with the safeguards of the European Convention, the Court was prepared to interpret Article 5 and take into account humanitarian law. The Court stressed, however, the quintessence of the right to freedom and security, namely the protection of individuals against arbitrariness. Now, once the applicant's detention was deemed to be in compliance with IHL, it was deemed lawful within the meaning of Article 5 of the Convention. In other words, the fundamental purpose of this provision, the ban on arbitrariness, was achieved. Similarly, and we have to concede this, the Court showed pragmatism by agreeing to lower the standard of protection under the Convention in order to accommodate the situation prevailing in the context of an international armed conflict. The case of Georgia against Russia No. 2, which is currently pending before the Grand Chamber, may well raise similar issues. By way of conclusion, it should be recalled that the European Court of Human Rights has had to deal with the principal aspects of the crisis that our continent is currently experiencing. Without engaging in any form of activism, it has broached with wisdom the issue of the economic crisis by applying the principle of subsidiarity to wide-ranging economic decisions. At the same time, it has been careful to preserve the essence, namely those non-negotiable rights, the principles of the rule of law and the principle of non-discrimination. On the refugee crisis, the case law of the Court is a veritable compass for states and the European Union. It enhances the protection under the Geneva Convention on the status of refugees. It highlights the need to rethink the Dublin system. It establishes that red line not to be crossed in crucial areas such as conditions of detention, living conditions of asylum seekers, the lawfulness of their detention or collective expulsions. The wealth of case law concerning terrorism does not, of course, fight shy of the real difficulties involved in combating this scourge. The Court has reasserted, in keeping with its established case law, its position, but has developed certain areas. It refuses to be locked into this false dilemma pitting freedom against security. It advocates both freedom and security. Alongside this, the Court has had to decide issues dealing with virtually all the armed conflicts on our continent and even beyond over the last few decades. Through the establishment of the interstate application, the Court has examined particularly controversial cases. It emphasises the erga omnes effect of its case law and has advanced the interpretation and application of the Convention. The recent shift in approach to international humanitarian law may herald a new phase in the Strasbourg Court's case law. Overall, the European Court of Human Rights is not only the most busy international court with the heaviest case law, it has also shown the necessary courage and wisdom to examine a great many delicate cases in legal, political and human terms, and I think we should be mindful of this major contribution before launching into sometimes glib criticisms of more secondary aspects of the way it operates. The Court is constantly striving to live up to its vocation as the guardian of the democratic ideals and principles of our continent. Thank you very much.
Merci beaucoup.
Thank you very much, Judge Sicilianos, for that very insightful, profound and comprehensive presentation in which you touched on a variety of very important issues. Well, I think the richness of your presentation will no doubt prompt questions and give a great deal of food for thought. I can still remain with you for about a quarter of an hour. I will have other matters to attend to, so I will at least be present to listen in to this dialogue, which we will now begin with members of the audience. So perhaps I could turn to the audience and ask you whether you have any questions to put or any comments to make. Claire Oley has stood up. You have the floor, madam.
Il y a un micro baladeur, donc voilà.
We have a roving mic.
In English, if you don't mind. I thought it was very interesting indeed what you said about the fact that difficulty in executing interstate cases is not a reason for the court not reaching decisions in these cases, not just interstate cases, but all sort of political cases. And I wonder if you could elaborate a bit on what you said about the value of such cases still remaining, even if they are difficult to execute, if they're not executed for a long time. And I also wonder if you could comment on any steps which the court could perhaps take to ease the execution process. I mean, I thought, for example, it's very useful, and these cases have not yet reached the Committee of Ministers, but in the Nagorno-Karabakh cases, that there are sort of parallel cases against Armenia and Azerbaijan, and I should imagine that the existence of these two cases will make the execution process perhaps a bit easier. And I just wondered if you could comment on any other thoughts that you might have about similar steps that the court could take in future interstate cases. Thank you.
Voilà.
Merci beaucoup pour cette question.
Thank you very much for this question, which is far from being an easy one. As I have said, I think that the value of these judgments is multifaceted. First of all, the finding of the facts is important for diplomats, for historians, but also in terms of establishing the truth. Establishing the truth in difficult cases, I think, is one of the major contributions of the court. So it's a matter of finding out exactly what occurred. And in interstate cases or interstate type cases, and you've referred to two of them, there is a very important section in the judgments on the finding of the facts. And I think that's a major contribution. Now, this sort of finding plays an important role at diplomatic level when it comes to negotiations between the states concerned. These were invoked on several occasions. For example, the fourth interstate case between Turkey and Cyprus was invoked on several occasions in the negotiations between these two communities. I think we shouldn't underestimate the importance of those cases for diplomats, as I say, but also for historians and for the victims too. They are keen to see that an international independent jurisdiction can establish the facts as they occurred for the victims. That's equally important. So, apart from the question of enforcement, which is different, the judgment itself, be it a judgment from our court or from the International Court of Justice, for instance, which has also been faced with very difficult cases involving resorting to force, those cases do have their importance, including for history. If you look at what the decision of the International Court of Justice says in the case concerning Nicaragua, although this judgment has not been enforced, it does have an importance in the relations between the countries concerned. So I think you have to adopt a long-term view when it comes to this sort of case. Now, what can the case do to contribute to enforcement or to execution? When it comes to execution, the court has taken major initiatives by developing the potential of Article 46 of the Convention by indicating in certain cases, when it deems it appropriate, individual or general measures which should be taken to enforce the judgment. This is something the court has been doing for some 10 years now with the approval of the Committee of Ministers. So the court has gradually evolved and taken up more of a role in enforcement, whilst, of course, trying to preserve the institutional balance. Now, is this a set of logics we could also transpose to interstate cases? I'm not sure. This is something we would need to reflect on further. So far, the court has been hesitant to adopting the same logic in the interstate cases. We need to be cautious. Obviously, enforcement is something which is dealt with mainly by the Committee of Ministers. Thank you very much. Another question?
Merci infiniment pour...
Thank you very much for this extremely interesting conference. I would like to ask the following. You have mentioned two types, or rather 4 types of crises for Europe: the economic crisis, the migrant and refugee crisis, the fight against terrorism, and armed conflicts. I would say that there's a 5th sort of crisis aboard, and that is the systemic crisis. And I mean by that a certain trend I can see not only in Europe but also more globally, a sort of centrifugal tendency with less and less trust on the part of populations when it comes to human rights protection systems. And I'm thinking of this judgment of the Russian Constitutional Court, which has become famous, handed down in July of this year, on the force of our own judgments in the Russian system. And I think you didn't mention this, of course, because it's slightly separate from the 4 other types of crises, but this would be my question. Do you think that these 4 types of crises can be considered as 4 different symptoms of a deeper and a more general phenomenon? To go back to the philosophical meaning of the term crisis itself, do you consider that these are 4 separate phenomena, or whether they can be the symptom of a much deeper crisis? And what do you think of the way in which the court should take on board perhaps this much deeper crisis we're experiencing? Thank you very much. You're very well known at our court for asking very philosophical questions and very far-reaching and profound questions. Well, first of all, I think that these 4 aspects are interlinked, and I said as much during my paper: the economic crisis, the refugee crisis, armed conflicts. Of course, why are these refugees arriving in our countries? Thank you very much again, Dean, for coming. Why are these refugees coming to our countries? Well, simply because of armed conflict or extreme poverty in their own country. So clearly all of these aspects are linked. Now, are these symptoms of a more profound crisis, a crisis of values, a systemic crisis, as you called it? That might be the case. In fact, our court has also had to examine certain aspects of this sort of crisis in its judgments, everything to do with living together in a society and the problems this poses. And I think that, yes, we might think about this in further depth and address the links between the different symptoms of the current crisis and reflect upon this further. And I think this will be the topic of one of the future conferences. But I do agree with this. All of this is not coincidence. All these phenomena are linked. And there's something deeper underneath, indeed. Ambassador Perakis. Allow me, first of all, to underline that I'm speaking here as a professor, not as an ambassador. I just wanted to make that clear. Sincere congratulations to you for this extremely rich analysis you've presented to us and everything you've told us about what the court is doing and about the future. And I think that these 4 topics you address do reflect a de jure and a de facto situation that the court indeed is called upon to address. And I think you made a very good choice in your topic. I'd like to make a few comments and perhaps put a question to you. First of all, the cautious position of the court when it comes to the economic crisis and recognizing the government's margin of maneuver. That's very important. In the case law you mentioned, well, clearly, I think that this is a very balanced position. Now, there are other bodies at the Council of Europe, like the European Committee for Social Rights, which go as far as finding actual breaches as a result of legislative measures taken in connection with the crisis. So, my question is, given the situation, and given the number of applications lodged before you and before other European bodies, do you think the court should remain on the same line, if you like, stick with the same position, or perhaps seek to be more far-reaching? You've also mentioned the refugee and the migrants crisis that the court has already had to deal with, but let me say that if we look at what European governments are doing and how they look upon migrants and refugees, my question is the following. In this extremely interesting case law you were referring to, does the court take into consideration the fact that the persons who travel, and I'm using the term travel deliberately, people who travel, who move from one country to another, what unites them? Well, of course, they're different from nationals insofar as they're aliens, but they have not yet become refugees. That's a status. They might be considered as migrants, but it's no coincidence that in Brussels or in Strasbourg there is seemingly some hesitation in the terms to use. And I think the court should take into consideration the particular regime which applies to these individuals. You alluded to a case. Now, I wonder whether the court has adopted a very balanced position when it comes to the case law stemming from the United Nations Security Council resolutions. The Court of Luxembourg has also had to address this. Now, do you think that the court will continue on the same line of reasoning? That is, that the Charter of the United Nations and Article 103 in particular impose that all these measures have to be complied with, and this is something that I personally find rather objectionable and that I tend to contest. And then I have another question. You referred to Behram Salamati. What can be done when we're dealing with de facto situations? There are many regions in Europe today which do not come under the sovereignty of a state, for example, which are governed by the United Nations or by NATO. What is the position of the court on this? And then I have one last point I would like to raise when it comes to interstate applications. I think that the initial purpose of the founding fathers of the Convention was to set up a system whereby all states would have rights and responsibilities. in the protection of the rights enshrined by the Convention. The first major interstate application was Austria-Italy, where this question of state responsibility was dealt with. Now, as far as I can see, a lot of these applications involve a national interest. Georgia against Russia, Ukraine against Russia, Cyprus against Turkey, and Greece against the United Kingdom in the 1950s. There are very few cases, and these are cases against my country, Scandinavia against Greece under the colonel's dictatorship, and then 5 applications against Turkey because of the dictatorship in 1982, where we have seen a national interest at stake. Now, we are a rather unique court here in all of the human rights protection systems in the world. It's, I think, the only court where such interstate applications are possible. And I do have these questions, and I also wonder about the lex specialis when it comes to international humanitarian law. Thank you very much. I'm sorry that I spoke at such length. Well, I'll try and start with the end, the lex specialis. This is a term which is not used by the court. It's a court which was used on one occasion by the European Court of Justice in its advisory opinion on the wall, but it's not by chance, as the President of the International Court of Justice said himself here during a recent colloquy in May of this year. It's no accident that the International Court of Justice has been reluctant to refer to this problematic notion of lex specialis. Now, when it comes to interstate applications, it is true that most interstate applications reveal a certain interest on the part of the state which lodges them. But this is not decisive as such, in my opinion. The former Human Rights Commission had said as much in the case of Austria against Italy, where there was a national interest at stake. So for me, this is far from being decisive. As you have said, in the Greek case in particular, some states had sustained no subjective damage, but they nevertheless lodged an application which had far-reaching consequences. Now, when it comes to the link between the UN system and our convention system, I think that the Nadar against Switzerland case provided one answer to this. In this case, did find a breach of the convention. And there's another pending case, Al-Doulimi against Switzerland. Again, I belong to the judgment formation, so you'll understand I cannot say anything to you about this case. The judgment will be handed down in the near future. And I think that you might find another reply to your question there. When it comes to the terms migrant crisis, refugee crisis, is this, well, what does this reveal, including in the court's use of these terms? Now, according to the HCR's more recent data, the flows of individuals we're seeing today, well, 80 or 90% of them are potential refugees, but there would be apparently 10 to 20% of them which will not be entitled to claim the status of refugees. We can't just say that we are seeing flows of refugees. These are mixed flows, as the High Commissioner of the United Nations for Refugees has said. Now, to provide a more legal answer to your question, our Convention and our court are not very interested in the status of individual persons. We have always said a person cannot be deported to a state where they risk being tortured, whether these are migrants, refugees, would-be refugees, even if they're terrorists or members of a criminal organization. That does not matter. The court is not interested, at least when it comes to the principles, in the status of individual applicants. Now, in order to assess the risk they pose, of course, that needs to be done. If it's somebody who's already a refugee officially, that, of course, will be taken into consideration. But to begin with, the person's status is not decisive to examine the applicability of Article 2 or 3 or 6 of the Convention or any other provision in the Convention. So it's not the status as such which will be decisive to begin with, but it will be the de facto situation and the risk of being subjected to ill treatment in particular. Now, to come to your first question and the approach of the European Committee for Social Rights as compared to our court, I don't necessarily see any contradiction there. The Committee on Social Rights reaches decisions on the basis of the European Social Charter, which is an instrument which contains a number of rights which are not covered by our convention. We adjudicate on the basis of property right, where the court invokes the subsidiarity principle in order to recognize a margin of appreciation to the legislator. So, according to the constant case law of the court since the 1980s, the court does not guarantee a certain level of wages or pensions. Now, it would be difficult for the for the court to tell the legislator at this point how it should organize its austerity measures and whether certain categories of persons need more protection than others. All of that is extremely delicate, and the court would rather not venture onto that rather dangerous terrain. Now, there will be other important and delicate cases in the future. There is a case involving Greek treasury bonds. Now, I cannot say any more at this point. This case is pending. The case file is ready. The state has responded, as I'm sure you know better than I do. So have the applicants. There are 7,000 applicants in this case, and we have communicated 3 applications to the Greek government. We will see what happens. So, to summarize and to reply to your question, I am sensitive to what the European Committee on Social Rights is doing. Their angle is different, their perspective is different. Of course, social rights are the first to be affected. In the case of a crisis, this is something we can't deny. And I'm in no way shocked by what might look like a difference of approach at first sight. I think Mr. Stavros has asked for the floor at the back.
Thank you very much. I wanted, first of all, to congratulate you on the presentation. You have said everything about what the Court of Human Rights can do to protect human rights at times of crisis. My question is what the Court can do on its own to protect human rights during a time of crisis. So already Claire referred to the role of the Committee of Ministers. I wanted to ask you about your views on whether in the Council of Europe we have a system for protecting human rights, in the sense of whether the court has sufficient scope for dialogue with other human rights bodies concerning the questions that have been raised in your presentation. So Professor Barakis already referred to the relationship between the court and the Committee for Social Rights. One can ask the same questions about the CPT, ECRI, concerning two of the topics that you have referred to. And the second question is whether our organization has sufficient systems in place to make sure that the impact of the judgments of the court is also heard outside the Council of Europe, especially in these very sensitive fields that you have touched upon.
Oui, merci beaucoup pour cette question. Concernant le dialogue.
Thank you very much for your questions. When it comes to the dialogue between the various Council of Europe bodies, I have to say that the Court has recently considerably added to the first section of its judgments, the section entitled The Facts, but which in fact goes much beyond the particular facts of the case at hand. And in that section you'll find a number of references to ECRI, to the CPT and to other Council of Europe bodies, such as the Committee of Ministers, the Parliamentary Assembly. And the Court has considerably added to its judgments with all of these references. Now, in the As to the Law section, these references are not necessarily repeated one by one, but clearly if they are contained in the first part of the judgment, then they can be used as a source of inspiration, but also as a very practical source for the Court's reasoning. So as far as the Court is concerned, I think it's done a lot. I'm certain it could do more. It could also make this first section in its judgments more systematic, but we are working on this. We are thinking about this in our group on working methods. We want to make the first section in our judgments more consistent. I think that when it comes to the exercise of its judicial role, I think the Court has done a lot over the last years to establish a genuine dialogue, not only with our other Council of Europe bodies, but also with the International Court of Justice or the Inter-American Court of Human Rights. We often quote that system. We also have contact with the Court of Justice of the European Union or with the United Nations. I think that we are the international human rights protection body that quotes others more than others quote it. So if you take a close look at what the Court has been doing in this connection, I think it has done quite a lot. Now, does the Council of Europe has the necessary means to cope with the consequences of the crisis? Are we equipped as we should be? I'm not sure. I think that a number of bodies are set up gradually. The Council of Europe does react, and in keeping with its rather limited resources, to be frank, but I think that the Council of Europe and its various bodies, including the Human Rights Commissioner himself, have said and done a great deal at different levels and dealing with different aspects of the crisis. I'm not sure whether we can say that there's a really structured approach. This is something I think we can work on building, but I think we were rather taken by surprise by the crisis, at least some of its aspects, including the migration crisis. And I think that ECRI and other of the Council of Europe's bodies have reacted pretty firmly and have laid down the principles that need to be upheld. And I think this has also sometimes been a source of inspiration for member states. So I think that the Council of Europe as an organisation has done a lot with its limited resources and will continue to do so.
Oui, s'il vous plaît. Oui. Yes, of course.
Thank you, Judge. First of all, I will be brief because I'm not in a position to be philosophical like one of the previous speakers. Neither am I a professor like my good friend and colleague, Ambassador Perakis. I'm the Turkish ambassador, but I'm here I'm sorry. I'm here rather as a student, and I benefited a lot. Thank you. Important contribution, and I hope you will make the text of your statement
it will be published.
Available.
Yes, and the text will be published. Yes.
And after these remarks, I have a brief question, Professor. Judgments. Some judgments are adopted unanimously, and some are by majority. Mm-hmm. Of course, for me and for my government, judgment is a judgment. They all have the same effect in terms of enforcement or execution. But sometimes I hear arguments in regard to non-unanimous judgments regarding the impact on enforcement. Would you care to comment on this?
Mm-hmm. Merci beaucoup, Monsieur l'Ambassadeur.
Thank you very much, Excellency. Well, as you yourself stated, there is no difference whatsoever in legal terms between judgments adopted by unanimous vote and those adopted by majority. Both types of judgment have exactly the same force, weight, and legal effects. Now, our system is a democratic system. That means that every judge, member of the convention, can express his or her view freely. Just because a judge is in a minority, that doesn't necessarily mean that a judgment will have less effect. Now, in the Grand Chamber and in the Chamber, we do try to produce unanimous judgments, but sometimes the case may arise that the issues at stake are such, the problems may be very controversial, it's a very close result, it could go either way. But ultimately, there is a majority and a minority. The majority wins the day, but even judges in the minority in subsequent cases will follow the majority. That's a matter of judicial ethics, but they are allowed to express their opinion so long as they respect the position of the majority. But I don't find in dissenting or separate or partially concurring opinions anything that might distinguish between the force, weight or effects of the judgments. All the judgments handed down by the court are mandatory. The distinction you mentioned too might have an effect on a body that only produces recommendations. I mean, I was once the vice chair of the Greek Human Rights Commission, and I always said we need to work on the basis of consensus, or seek to do so as far as possible. Our recommendations are addressed primarily to governments. The persuasiveness of our texts will also depend on the extent to which we have been able to reflect in that text the common feeling of all the persons represented in that national body. So a body which produces mainly recommendations should, as far as possible, seek to arrive at a consensus or a quasi-consensus, or shall we say at least a broad majority, so that it can carry persuasion with the government, or let's say the people the recommendations are addressed to. But where you're talking about an institution which produces mandatory judgments, that judgment will be just as forceful whether it was carried by a majority or unanimously. For me, there's no difference to be drawn there. Now, admittedly, some might argue, by way of doctrinal literature, that some criticisms might be levelled against judgments handed down where there is a large minority. And of course it may well be that by the process of democracy, a minority view held today may turn into the majority view tomorrow. But when it comes to the execution of judgments and the responsibility for states to execute that judgment, I would draw no distinction between judgments carried by a majority or unanimously. Thank you. Our legal advisor. Thank you for this excellent lecture. You took a little over 1 hour to give us a very comprehensive overview of the fundamental issues that the Human Rights Convention system has got to confront. I deliberately chose to speak in terms of a system, and this ties in with what other speakers have said. The court is the hub or the centre of the system, but it's a broader system as well. There's the Committee of Ministers, which has its role to supervise execution of judgments, plus the Secretary General, who plays a political role and who is equally active when it comes to exercising political pressure or using political contacts to strengthen execution of certain judgments. And of course, speaking as the legal advisor, I know what I'm speaking about. As to some technical issues, you mentioned the Abu Qatada case, and you stressed that this was the first time that the court relied on Article 6 in relation to an extradition. First time we applied Article 6 in an extradition case. Well, it seems to me that that type of case law does raise some issues. It's an important judgment, but of course it is a matter which is under debate, because previous to that judgment it was mainly Article 3, torture or inhuman treatment, that were addressed. If you look at the repercussions of this outside the frontiers of Europe, this might be perceived as a judgment being made on other judicial systems outside the convention system. So I think we need to step up our didactic efforts and explain more what this approach entails. So this brings me to my question. I was struck by the final part of that judgment. In the operative part, it states that extradition would violate Article 6 because there would be a real risk of the applicant being tried during new proceedings on the basis of evidence extracted under torture. So Article 6 is being applied, but indirectly there were also components of Article 3 which came into the picture. Now, I'd like to know whether your court has had occasion to further develop that case law following that judgment. I think that there is a major concern here about the forcefulness and consistency of the approach, because after all you are dealing with judicial systems which are not in themselves linked by the convention system. Thank you very much. Well, of course, in the Söring judgment, which we all know about, which dealt with someone who might have been subjected to torture, that issue already arose. But something was also said about the risk of someone being subject to a flagrant denial of justice. So that concept has been around since 1989, the Söring judgment. Now that case has been revisited by the court and has dismissed that claim, finding no such risk to exist. But up to Abu Qatada, that case law was never actually applied to actual facts, actual events. Now, the court did, in that case, undertake a very searching analysis of the Jordanian system and events which had occurred previously in Jordan. So it obviously didn't come to that finding without serious, meticulous consideration of all the risks involved. Now, of course, it does express a view on foreign judicial systems, but the same applies when alleging a violation of Article 3, torture, serious inhuman treatment, or Article 2. So I think we can only speak of extraterritorial application of the Convention in inverted commas. You know, the court, in making its judgment, may implicitly be making a statement about the human rights protection system in Council of Europe member states. There are lots of judgments on Kazakhstan, Uzbekistan, and so on, dealing with like traditional torture cases, which also involve an evaluation of the effectiveness of human rights protection in non-Council of Europe member states. So why do this under Article 3 but not Article 6? Especially as you quite rightly stated, Article 6, the right to a fair trial, and Article 3 are closely interrelated in the facts of that case. So I think this was unprecedented, but a very good move forward in the case law. I mean, unless I'm mistaken, since that judgment, you have not had the same finding in other judgments. So if you like, the court is very reserved when it comes to assessing the effectiveness of the judiciary in non-member states. But if it does so, it needs to feel that it's on firm ground in saying that. And perhaps one final question. Yes, good morning. Thank you very much for this very interesting lecture. I'd like to put a question concerning lex specialis. We know that in the Termo case, the ICJ specified the principle of the Human Rights Convention being a lex specialis. Now, the ICJ didn't mention that explicitly, but we know that this is a concept which will tend to take precedence in the legal literature and in practice as well. I could refer to Sassoli, Schmidt, or indeed other legal writers. Anyway, this approach to lex specialis concerning international law with respect to human rights should be taken into account. And I wonder whether the approach you have in the European Court does not tend to humanize international humanitarian law. And if we bear in mind, for example, the Chechen cases among others, I'm wondering whether the approach taken by the court is consonant or not with that particular interpretation of lex specialis as opposed to lex generalis. Well, first of all, there is no unanimous position taken by legal doctrine. Cansardo Trindal from the Court of Justice has produced a very interesting book on the sometimes deleterious effects of the concept of lex specialis. So it is a rather vexed concept. Emmanuel Rucuna talked about parallel and contradictory obligations, speaking for the International Academy of Law. And as I stated myself, the International Court of Justice has avoided using the term in its judgment concerning military and paramilitary activities in the Congo and on the Palestinian Wall advisory opinion. So I think we need to be a bit more cautious. These are two legal bodies of provisions which coexist. We would, of course, be keen for there to be a harmonious interpretation of both. That's what we sought to do in the Fassan case. We didn't state that humanitarian law was a lex specialis which should take precedence over the convention. No, we attempted to interpret the convention in the light of international humanitarian law, sort of combined, harmonious approach, a non-conflictual approach in legal terms, not based on some concept of a hierarchy or clash, but rather placing the focus on harmonization. And I think that's a more productive approach, closer to reality and consonant with the role of the court, which is primarily the guardian of the convention. Indeed, the dissenting judges expressed some reservations about that court's approach, stating that according to Article 19 of the Convention, the court does have competence to apply the Convention nothing but the convention, the whole convention. So personally, I would tend to agree with the position taken by the majority, the position of the court. I was not a member of that particular composition, so I don't feel able to speak any more about that. But I think the position taken by the court was a very cautious one. They didn't talk about lex specialis as such, but they attempted to combine, if you like, the two branches of international law in a harmonious way, according to the general approach that had already been laid down by the International Court of Justice, which always is keen to avoid speaking in terms of lex specialis. Now, I know that some experts in IHL are concerned to stress the paramountcy of IHL in all cases, but I consider that approach is perhaps a little too orthodox. No, I'd like to thank each and every one of you for being here, for putting your questions. Thank you.
Μην εξαφανίζεις, θα μπορούσα εδώ, γιατί